Global happenings today. We communicate, we analyze global news. Stay tuned.
Hello, beautiful people. Welcome to Global Happiness today. Nnamdi Kanu's legal team have decided to brace up and do what is necessary for Nnamdi Kanu to be released, no matter whose heir is being gone, and have decided to also sue the chief judge if need be for Nnamdi Kanu to get the most required fair trial or at best get released unconditional. In a moment, you're going to find out the processes involved and what they intend to do. It looks like Nnamdi Kanu is on his route to a win-win situation. Before we go into the newspaper, we'd like you to subscribe to our channel by clicking on the red subscribe button. Beside it, you'll see the notification icon. Please go ahead, click on it to get notified as soon as we update our channel on YouTube. Well, some weeks ago, Justice Soho issued practice directions on trial of terrorism cases, noting that the distance and size of perimeters to be secured for the trial shall be determined based on the recommendation of security agencies on a case-by-case basis. Leader of the indigenous people of Biafra, Nnamdi Kanu, has sued the Chief Judge of the Federal High Court of Nigeria, Honorable Justice John Soho, and the Chief Registrar of the Federal High Court of Nigeria over the new practice directions on hearing of terrorism cases. Some weeks ago, Justice Soho issued practice directions on trial on terrorism cases, noting that the distance and size of perimeters to be secured for the trial shall be determined based on the recommendation of security agencies on a case-by-case basis. It means terrorism trials, including the ongoing trial of Nnamdi Kanu and other related ones, will be done secretly, even without journalists, except the judge rules otherwise. Kanu's trial by the Nigerian government, which continued on April 8, was the first casualty of the new directive. In an originating summon with suit number FHC /ABJ /CS /550 /2022. Kanu was filed on Monday. Which was filed on Monday, April 25th. Kanu's lawyer, Ifeanyi Ejiofor, sought answers to where the powers conferred on the first defendant, Soko, includes the power to make directions for regulating trials of terrorism offenses in the Federal High Court, considering the provisions of Section 36, subsection 1, and 364, subsection A and B of the 1999 Constitution of the Federal Republic of Nigeria as amended. Ejiofor argued that the said practice directions were issued without approval of the Federal Executive Council, formerly the National Council of Ministers of the Federal Government of Nigeria. The lawyer said that the indigenous people of Biafran leader, IPB leader Nnamdi Kanu, was not afforded any hearing before the said directions were made by Justice Soho. He further argued that his client Kanu, against whose interest the said directions were primarily made for, which is true anyway, has already been publicly trialed and condemned by the federal government of Nigeria and her Attorney General. That I know as a fact that it is in the interest of justice and fair hearing that the plaintiff, who has been so tried and condemned publicly by his accusers, enjoys a public trial devoid of restrictions contained in the practice directions, he added. He also noted that the practice directions apply to and affect the proceedings in charge number FHC /AB /CR /383 /2015 pending before Honorable Justice Binta Nyako of Court Number 2, Federal High Court, Abuja, in which the plaintiff is being prosecuted under the Terrorism Prevention Amendment Act. Ejiofor further urged the court to restrain the defendant and their agent from applying and enforcing the provisions of the Federal High Court practice directions on trial of terrorism cases in 2022. Other reliefs sought include A. A declaration that the provisions of the order of the Federal High Court practice directions on trial of terrorism cases 2022 are already the subject of section 36 subsection 4A and B of the Constitution of the Federal Republic of Nigeria 1999 as amended, and consequently they are inoperative and outrightly ultra-vires the first defendant invalid, null, void, and of no effect whatsoever. A declaration that the failure of the first defendant to first seek and obtain the approval of the Federal Executive Council or the National Council of Ministers of the Federal Republic of Nigeria prior to enacting the Federal High Court practice directions on trials of terrorism cases 2022 as required by Section 44 of the Federal High Court Act renders the Federal High Court practice direction on trial of terrorism cases 2022 ultra vires, null, and also void. A declaration that order 3 rules subsection B 3 rules 3 I think that again a declaration that order 3 rules 3B subsection D of the Federal High Court practice direction on trials of terrorism cases 2022, which respectively empower a Federal High Court trying terrorism cases to receive evidence by video link and also to receive written disposition of expert witnesses, are inconsistent with item 23 and 68 of the Executive Legislative List, as well as paragraph 2B of part 3 of the second schedule to the Constitution, which confers to the National Assembly the executive, or rather the exclusive power to make rules of evidence, both substantive and adjectival, and are therefore ultra vires, null, and void to the extent of the inconsistency. A declaration that order 4 rule 2 of the Federal High Court practice direction on trial of terrorism cases 2022, which provides that a person who contravenes an order or direction made under these directions shall be deemed to have committed an offense contrary to section 34 subsection 5 of the Terrorism Prevention Act 2011 as amended, as is inoperative because the National Assembly had already covered the viewed via section 34 subsection 5 of the Terrorism Prevention Act 2011 as amended. A declaration that the rulemaking powers of the first defendant under section 254 of the Constitution of the Federal Republic of Nigeria 1999 as amended are limited to the premises of the Federal High Court and do not extend to outside its perimeters, which are under the exclusive responsibility of law enforcement agencies such as the police, the DSS, and all that. An order of this Honorable Court declaring the Federal High Court practice direction on trial of terrorism cases 2022 unconstitutional, invalid, null, void, and of no effect. The defendants are expected to appear within 30 days of the service of the summons on them, inclusive of the day of such service case and appearance to be entered for them to this summons, which is issued upon the application of the above named plaintiff for the determination of the following question. It was further noted that the duo both of the Federal High Court may appear by entering appearance personally or by a legal practitioner, either by filing the appropriate processes as in Order 7 in response at the registry of the court where the summons was issued, or sending them to that office by any of the methods allowed by these rules. I guess this is a way of telling them that end of secret trial begins now. So they're actually challenging the secret trials so that Nnamdi Kanu will get a free and fair trial, and all journalists and the whole world will know exactly what is going on in the court premises. Let's get this. We're going to wrap it up. We're wishing them all the very best. Let's meet in that conversation.